I did want to go ahead and start then and kick us off for this exciting webinar today. The speaker, David Steinhart, who you will be hearing from, is the director of the Commonweal Juvenile Justice Program based in Marin County. He's an attorney advocate and expert on juvenile justice law, policy, and program development in California and nationally. He co-drafted California laws removing children from adult jails, expanding mental health services for justice system youth, and establishing state programs for local youth crime prevention services. He was instrumental in the design of multiple reforms, downsizing the California youth prison system, including a key role in the adoption of the 2020-2021 legislation that closed the State Division of Juvenile Justice. He co-drafted California statutes establishing local secure treatment facilities and the related process for local commitments of youth realigned from state youth institutions. He served as the California Supreme Court appointee to the statutory working group that advised the California Judicial Council on the adoption of the new sentencing guidelines for realigned DJJ youth. He is a lead advisor to the California legislators on a series of juvenile record sealing reforms enacted between 2014 and 2019. He served as the Senate appointee to the California Board of State and Community Corrections from 2012 to 2022. LaRon Dennis is currently an attorney and special consultant for the Office of Youth and Community Restoration, specializing in juvenile law and policy. Ms. Dennis is a retired prosecutor and former probation officer with 30 years of practical experience in the juvenile and criminal system, having worked within the executive, legislative, and judicial branches of state and local government. She has worked as a consultant for criminal and juvenile justice systems around the country in risk needs assessment tools, effective supervision methods, and other evidence-based practices. Ms. Dennis served as an adjunct professor and for over a decade was a contributing author for California's leading juvenile law treatise, Sizer and Cumley on California Juvenile Courts Practice and Procedure. She authored the first published academic article on California's deferred entry of judgment law for juvenile offenders, as well as other publications addressing juvenile justice systems issues, including girls, mental health, and the overall improvement of our system. I'm really pleased to be able to present these two experts today to guide us through the legal changes that have occurred in 2023. And at this time, I will hand it over. Thank you both.
All right, that looks like a pass to me. Thank you, Judge Lucero, for that introduction and long account of things that I've done and LaRon has done. My job today is to provide an update on new 2023 legislation. And my presentation goes a little bit beyond that because I've incorporated something I do in these trainings after talking with OYCR. And that includes a kind of update on the caseloads, juvenile justice caseloads in California done by charts and graphs assembled mainly from the JCPSS data system at DOJ. So giving you a long look at policy change. Yeah, there we go. There's the slide. Giving you a long look at some of the policy reforms that have affected caseloads in California. I'm going to take about 10-12 minutes on that and then segue into an update on newly enacted laws in 2023 for the rest of the presentation. Questions I think best to hold till the end. If there's something really burning, I will ask Judge Lucero to jump in or somebody and say, got to do this, but let's try to hold the questions if we can. So let's go ahead, Austin, and put it on slide number 2, just to give all of you an outline of what I'm going to do here. As I said, I'm going to start out with some caseload trends and then go into new legislation. From these bullets, you can see some of the categories or subject areas that I'm going to talk about. Budget bills dominating the action. We'll talk about new law on county juvenile facilities. I'm going to spend a fair amount of time talking about secure youth treatment facilities, which are the sort of surrogate replacement facilities for the Division of Juvenile Justice at the local level. There's some new law on OYCR, some new law on transfers to adult court, and so on. And I'm going to finish up with a mention of a couple of vetoes and at least one bill that's interesting for 2024. There's a handout, the bills I'm going to talk about, I'm going to do kind of wave tops here, the main points, just to alert those of you who are listening to what's happened and the main points. But some of these bills are very intricate and require a deep dive. So there are other resources for that. One is a Commonweal legislative report that we do at the year's end that's available through OYCR, and of course the bills themselves online. Just fair warning, some of my slides are a little bit dense. They don't follow the PowerPoint rule of 2 bullets per slide, but I do that so that we can avoid having a whole lot of slides. And so if you want, you can open the slideshow back, look back at it and get the detail, finding it on a single slide. So let's go ahead, Austin, and take the next slide. So looking at some data trends, 2022 is the last data year that Department of Justice provided its tracking on. And so we can see here, this is just total juvenile arrests in California. There were 26,000 of them in 2022, and they break out about 45% of them are for felonies, the others for misdemeanors. And yes, we are actually still arresting some status offenders, believe it or not, but that number has declined substantially. The overall trend is way down over time. Interestingly, there's a bit of an uptick in total arrests for 2021 to 2022, a 34% increase. We'll talk about that. I'm not sure what's driving that, but the overall trend down by 80% over the last decade, which is huge. Let's flip to the next slide. This shows a sort of more drilled down picture of California juvenile felony arrests. We're concerned about serious crime, and this is the long run. This is 25 years of looking at juvenile felony arrests in California. And look at that trend. It's just an astonishing downward trend. The bars show the number of arrests per year for felonies in California. And the interesting bar or line is the red one. That's the rate per 100,000 kids in the population aged 10 to 17. And so that rate has declined by about 85% over 25 years. So, something is right. Something is right in the California juvenile justice system. A lot of people point to this or that or take credit for this decline, but the decline is real and very compelling. Again, note that little uptick between 2021 and 2022 in more juvenile arrests. These are just arrests. They're not crime reports. I tried to look a little farther into whether the arrests were resulting in more petitions filed, and I got very mixed results. But every year we hear about crime going up when in fact it doesn't seem to be, but this bears a little watching. So we'll watch that coming up. Next slide. When we talk about arrests, we're always concerned about arrests for serious crime, violent crime. So here's a 6-year chart of arrests of juveniles for violent offenses, which are, you can see on the bottom, kidnap, rape, robbery, assault, and homicide. Most of the arrests are in the violent crime category are for assault and robbery. And those are most of the kids who went to DJJ. It was robbery and assault offenses. We do, again, have that uptick between 2021 and 22 in violent crimes, but we need to keep in mind that the long-term trend is downward, and downward. So just a quick look at that. Let's go ahead and do the next slide. So again, in this sort of wide overview, I try to accumulate a picture of incarceration. This isn't just incarceration. This is custody levels that include even private placements of probation kids in, well, group homes, but now it's STRTPs. But if you look at the 602s in custody over the period 2010 to 2023, another dramatic drop. I mean, the incarcerated youth population in California has gone down, down, down. Less arrests, less incarceration, the closing of DJJ. Many things explain this, but it's just a very interesting policy picture. that we've gone from these large numbers of kids locked up in California, locked up in general, down to about 2,600 total today. I note that this SYTF population, for those of you thinking about SYTFs, is split between camps and juvenile halls. We'll talk more about that in a minute. Let's go to the next slide. So I update this every presentation that I do. I call this the probation lens, and it looks at two types of facilities: juvenile halls over time on the left, and another graph with probation camps on the right. And the orange bars show the decline in the population. A familiar story: declining population, a little bit of an uptick in 2023. Of interest here is the gray area, the diagonal lines, the top, these graphs. That's the rated capacity that BSCC, Board of State and Community Corrections, keeps for juvenile hall and probation camp capacity in California. We built a lot of capacity, especially in the 1990s. But as these arrest rates and these incarceration rates have gone down, we have empty space. Those gray areas are empty space in probation camps and juvenile halls. The number's a little bit funky because it's hard to keep up with units that are closing and so on. But the general picture is that in terms of local juvenile facility capacity in the juvenile justice system, we're operating on an average statewide basis of 25% of that capacity, with the rest being kind of empty space. And of course, that's an issue for probation when it has to maintain facilities that aren't full, when it has to adjust facilities for new populations coming into security treatment facilities and the like. But always of interest to track capacity against population. Let's go to the next slide. So it used to be many years ago, at least in as far as I followed things, that having the private placement system available for delinquency placements was a very important tool for prosecutors, judges, and defense attorneys. But the ability to place kids with adjudicated offenses in group homes and private facilities has dwindled, mainly because the group homes have closed in California under what's called continuum of care reform since 2011. Also, the placements have gone down over time, as this graph shows, because of the decline in arrests. But the sort of private sector capacity to absorb youth with delinquency offenses has just dwindled substantially in California. Those placements are paid by the foster care system as well. So I think it's always interesting to note these CWS, CMS social welfare data on the number of kids that are going into and staying in private facilities. Let's go to the next slide. Division of Juvenile Justice. Most of you probably know that I'll call it the youth prison system because that's what I think that it was fairly called. That system in California used to incarcerate a lot of kids. So back in 1996, in this long-term chart, the population of what was then the California Youth Authority was about 10,000 kids. Today, that population is 0 because DJJ, which is the Division of Juvenile Justice, closed in July of 2023 this year, and intake in most cases closed back in 2021. So that population has gone down, down, down. And those numbers going from 2013 outward, around 600 kids in the institutions before they closed, the network of DJJ institutions, are worth watching because they should constitute a rough benchmark for the population of SYTFs at the local level that replace DJJ. We're always interested in net widening, meaning now that we've closed DJJ and are sending kids into local facilities, are we sending more than we sent to the state system or not? So let's go to the next slide. This is the annual juvenile court commitments to DJJ. I don't want to dwell on this, it's too complicated. But again, these numbers of commitments to DJJ before it closed in the last 5, 6, or 7 years, hovering in the 200s to 300s kids per year committed to DJJ. I see them as potential benchmarks for who should be what the number should be statewide for going into secure youth treatment facilities. We don't have good data on that, but I don't want to stick on this slide, but just wanted to make that point that we have some benchmarks there. Okay, let's shift again. Let's go to the next slide. Try to move it along. So let's talk about transfers of kids to adult criminal courts. This is just an amazing policy story, not only in California, but around the nation, that we see a decreasing reliance on prosecuting children as adults. We had key reforms in California. You see in the little boxes there, Prop 57, which banned prosecutorial direct file in California. Then we had legislative action saying 14 and 15-year-olds cannot be sent to adult court. And so you see these lines. So the red line was total transfers, and when we had the yellow line, prosecutorial direct file, those transfers were robust. But it's with all these reforms, look at the far right number at the bottom, 2022, 12. Can you believe that we in California in 2022 transferred only 12 youth to the adult criminal justice system? That is just a phenomenal change, driven by so many factors, including the United States Supreme Court adopting brain science and a set of reforms around being able to, lock up children and transfer them to adult court. So let's keep this in mind, because we do have a bill on transfer law this year that I'm going to talk about. Let's go ahead and flip. So this is really part 2 of my presentation, where I'm going to do a catch-up on new laws enacted in 2023, new juvenile justice laws. And again, I've broken it out by subject area. And there are a couple of reasons for doing that. Normally I go bill by bill, but this was a kind of an odd year because we had so many bills amending the same sections. It's really better to approach it, given the complexity of this legislative year, by summarizing by topic or issue area. So I'm going to talk about bills that affect all county juvenile justice facilities. I'm going to spend some time on secure youth treatment facilities, which I know many of you are very interested in. And then we have some bills affecting the realignment funding after the closure of DJJ, the money that counties get to inherit the caseload. There's some new law on the OYCR and the Ombudsperson Office, new transfer law, and then some others that I'm going to cover in the time available. A couple of general observations about the 2023 legislative year in California. This was not a year of big blockbuster juvenile justice reforms. A blockbuster year in my mind would be 2020, when we passed Senate Bill 823, that set up the closure of the Division of Juvenile Justice, or maybe a 2019 when we banned transfers of 14 and 15-year-olds to adult criminal court. But this was a year of, I call it a granular year, in which most of the bills of interest in juvenile justice were technical changes and implementation adjustments rather than any big, blockbuster legislation. And that actually made my job and your job as well a little harder, because we're down in the weeds in terms of understanding a lot of the law changes that came up in and apply in 2023. There was a big focus on secure youth treatment facilities. And like I said, we'll get into that as a kind of a separate area. Another note is that we had, as in prior years, a lot of the action through the budget process. And so this is just a sort of a policy methodology issue. Most of the major juvenile justice reforms, at least in decarceration and the closing of DJJ, were accomplished through the budget process. And that means that the big reforms are in budget trailer bills. And when you make a change through the budget process rather than through the policy process, The discussion is different. The outcomes are mainly agreements between the legislative leadership and committees and the governor's office and some of the key practitioner organizations, probation chiefs and so on. And there's a little bit of a less opportunity for public comment and input as you get in the hearing process. So it's a little bit of a more opaque process, and it is of interest that we do this from year to year, which is change and transform the juvenile justice system, relying so heavily on the budget process. Another factor is that when changes happen through the budget process, they become effective in the middle of the year when the budget trailer bills are adopted. And this creates confusion, especially for counsel and judges who have to kind of, leapfrog and jump to new rules and changes in the law, but they aren't in the code books. And they, lawyers have to remind judges that, hey, judge, the law's changed here and it's effective on July 1st and so on. So that's another artifact of using the budget process to change a juvenile justice law. Right now, it's moot because the budget bills and the policy bills are all in effect, the ones I'm going to talk about, as of January 1st. Let's go to the next slide. So getting into the issues at hand and the bills that were enacted, let's look first at some of the new law affecting all county juvenile facilities. And the first one I've identified, which was covered by a couple of bills, was a change in the mandate for what judges must inspect at the local level under Welfare and Institutions Code Section 209. The old law was the judges had to inspect only juvenile halls and lockups. Now that mandate has widened, and judges have to conduct annual inspections of camps and ranches as well, and SYTFs as well. So that's an expanded instruction or mandate for local judges under this law change, which was adopted in a budget trailer bill, AB 134. And that also means that the enforcement provisions, should a standard violation be found, now apply to camps and ranches and SYTFs at the local level, as well as at the parallel BSCC level, because 209 requires the Board of State and Community Corrections also to conduct those inspections and to enforce those minimum standards across all the facilities now, juvenile halls, camps, ranches, lockups, and SYTFs. So, that is a change. And then there's some more technical changes in the Board of State and Community Corrections language that relate to the minimum standards that the Board of State and Community Corrections adopts, Title 15 and Title 24 for juvenile facilities. BSCC is in process still in revising the Title 15 and 24 minimum standards for juvenile facilities, a biannual update. And under DJJ reform bills, they're required to adopt new specific standards for SYTFs that, as I understand it, are still in development. So we will be watching for those. Let's go to the next slide. So again, talking about all county juvenile facilities, we had some new law in 2023 affecting the separation of juveniles and adults in county juvenile facilities. So that became a more intense issue after realignment, because now we have juvenile justice facilities serving as SYTFs and holding young people who are staying for a long period of time, the new equivalent of the old DJJ sentences, and DJJ kids were staying for an average of 3 years. So as those young people remain in juvenile halls and camps that are SYTFs, they're going beyond age 18 and 19, and they can be held up until age 25 or a 2-year period of control, whichever is longer. So that raises issues around classification, security, and so on about commingling older and younger kids in confinement. And it raises a collateral issue about adult court people who might be eligible or people defined as adults who might be eligible to be kept in a juvenile facility. For example, kids who have already been transferred to the adult criminal justice system and are over 18. So this year, we added section 208.55, laying out further definitions of who's an adult and who's a juvenile for purposes of being held in a juvenile facility. The language adopted was that an incarcerated adult, as defined, cannot have sight or sound contact with a juvenile as defined in a county juvenile facility covering halls, camps, ranches, and SYTFs. And sight and sound contact is redefined. As you can see there in the second bullet, any physical, clear visual, or direct verbal contact that is not brief or inadvertent. The definitions of who's a juvenile and adult are laid out. So a juvenile is defined as a person under 18 or under continuing jurisdiction of the juvenile court, or their case originated in juvenile court. And an incarcerated adult is a person, okay, this slide didn't get corrected, is a person over 18 who is not subject to juvenile jurisdiction. That was an error that was supposed to be corrected. And you can see that. This gets complicated. I flag it. You probably want to read 208.55. And then another note here is that this all relates to changes that were made in section 208.5 in 2020 and 2021. Again, creating room to keep youth in a juvenile facility, notably in an SYTF when they become older than 19. So under the old 208.5, there were rules for transferring kids to an adult jail when they aged out in a juvenile facility. There were changes that provided for, if you reach 19, then probation can request that you be moved to an adult jail. But you know, I don't want to go way down in the weeds on this, except to say that we have new law that endorses the ability to keep a person committed to a secure youth treatment facility in a juvenile facility until age 25 without having to separate them from incarcerated adults. I know that sounds a little complex if it's new to you, but I think that's as far as I want to go with that one at this point. Let's go ahead and go to the next slide, please. So I'm going to segue into talking about secure youth treatment facilities as a kind of a separate subject. And I put this slide in here to sort of back up a step and cover some of the basics about youth treatment facilities, particularly if there are people participating in the webinar who aren't all that familiar with what we're talking about. So when we closed the Division of Juvenile Justice, the state youth prison system, in July of 2023, we transferred the control of all of the cases and kids that used to go to the state system to counties. And where would they go? Well, we, in designing secure youth treatment facilities, needed to design a parallel and surrogate secure custody system at the local level, and that turned out to be secure youth treatment facilities. So we created eligibility criteria and court procedures and other criteria for who's in an SYTF and how long they stay there. All of that detail is loaded into Welfare and Institutions Code section 875, defining what the facilities are, what the commitment criteria are, what the sentencing guidelines are, providing very importantly for review hearings, treatment plans, talking about step downs where young people could be moved from secure to a less secure program and so on. So I'm certainly not going to go over every nuance and iota of Section 875, but we did make law changes in 2023 affecting Section 875 that I'm going to talk about. It's important to recognize that in July of 2023, the state judicial council's SYTF sentencing matrix became effective. And that is the set of guidelines that judges use to determine how long somebody with a serious 707B offense will be sentenced to a local SYTF. So we established with the new matrix, the judicial council matrix now in effect, provides range-based terms for kids based on the offense as a baseline term for being committed to an SYTF. And this new baseline term system replaced what I have to call a very confusing and unsatisfactory set of sentencing guidelines that were in place at DJJ. So secure youth treatment facilities are now taking the place of what used to be DJJ and are operating at the local level. And we have some law changes to talk about. Let's go to the next slide, please. A secure youth treatment facility does not exist in every county. If you are a county operating a secure youth treatment facility, you need to register that with the Board of State and Community Corrections. Currently, 36 counties are operating an SYTF, according to BSCC. Most of those SYTF facilities are located within juvenile halls, within existing juvenile halls, which raises some issues we'll talk about in a minute. So juvenile hall SYTFs in California, about 27 of them. The rest are mixes of camps or camp and juvenile hall SYTFs, as you can see from the third bullet there. How many kids are now in secure youth treatment facilities? This is the DJJ shifted population of kids with 707B adjudications who were over 14 at the time of the offense and got committed to an SYTF. The latest numbers we have are about 510 juveniles in county secure youth treatment facilities statewide. My bet is that number is going to grow because we're only in the second year of commitments, and some of these young people are serving multi-year commitments, even with the ability to reduce sentences. So it remains an issue. It's sort of a moving target as to what the total state population for SYTFs will be in the coming years. Data, we don't know much more about the young people in California who are in SYTFs, other than how many are there total by the counts that BSCC is producing. We don't know what their commitment offenses are. We don't know what their baseline terms are. We don't know what their race ethnicity is. We don't know what their gender is, not on a statewide uniform basis. We don't know how long they're staying. And that's because we have declined, despite many attempts, to mandate the collection of uniform statewide data on SYTF populations, except for some limited data that OYCR will now collect, and I'll talk about in a minute. Let's go to the next slide. Changes in SYTF law for 2023. Some critical changes in the process. Here's a big one. Section 875E is amended to add a ban on plea bargaining stipulations that seek to tie the court's hands in setting baseline terms or modifications of baseline terms in review hearings, or seek to bar referrals to an LRP. So under the old law, it was an open question as to whether the DA and the defense counsel, in order to avoid a transfer hearing, might agree that there would not be any reductions in review hearings of time, or that no LRP would be on. You can't do that anymore because this law says no plea bargaining agreements in advance to tie the court's hands. The language is very clear, I think. You can see it in the italics there, saying that the determination of the baseline term modification or referral to an LRP is a judicial decision and judicial discretion and cannot be pre-stipulated by the parties. So that's important for practitioners. Another amendment to 875E3 on SYTFs clarifies kind of an open issue with respect to less restrictive programs. When we drafted Senate Bill 92 and created less restrictive programs, it was a less than fully satisfactory piece of SB 92. We left a lot of loose ends in defining what less restrictive programs are. Basically, they're meant to be a step down from secure custody for kids who are doing well in SYTF confinement. And the judge can order that. They can be operated by a community program or by somebody else, but they're not very closely defined. And what was left out was whether kids who are sent to LRPs, and we don't know how many are going because we don't have the data, whether they have to have 6-month reviews. This change does require that somebody who is in an SYTF and is referred to an LRP must have 6-month court reviews. And then it sets out some of the process terms as to what the court can do in those reviews. They can reduce time on the LRP order. They can't add to LRP time without making other determinations under subdivision F with regard to material failure to follow conditions. Again, I don't want to go deep dive into that, but just want to flag it as a change in how LRP programs are managed. Let's go to the next slide. Okay, now we're getting even deeper into the weeds of change here. There were other budget bill changes affecting SYTF caseloads. The top one there is one that affected kids who were still in DJJ when it closed and went back to county, and many of those are going into SYTFs. This amendment to Section 875B provides that a youth returned from DJJ with remaining DJJ time cannot be given an SYTF baseline term that exceeds the DJJ release date that the young person had in DJJ, otherwise known as the PCD. So there's that cap on the new sentencing. Also, that the youth has to be granted credit for programs completed or substantially completed at DJJ. Another change has to do with remanded youth over age 25. You know, we have this flow of youth getting resentenced from adult convictions and coming back to the juvenile system, a kind of a trickle, but a set of laws that permits that to happen for kids who were in state prison for very long terms and for offenses committed when they were juveniles. So some of those people are over age 25, which is pretty much the cap on juvenile jurisdiction. And the question is, can they, if they're remanded back to juvenile, be kept in a juvenile facility or an SYTF? And if they're over 25, the allowance would be under the 2-year period of control rule, which says that jurisdiction can be age 25 or a 2-year period, whichever is the longest. So this change, it sets out some criteria for the, let's call it the housing of remanded youth who are over age 25, and says that under limited circumstances, the judge can decide to place them in a juvenile facility, or the judge can authorize detention in adult jail, or can authorize a referral to an LRP. So again, I don't want to go any deeper into this. It tends to be complex, but just to recognize the change that was adopted. And then for an even smaller population, we added a new subdivision K to 875 for kids coming back from DJJ who had been sent to state prison for an offense committed in DJJ, now coming back to county under juvenile jurisdiction. We got layers and layers there. This change provides dispo options for those young people, including giving them a choice to serve out their sentence in CDCR. Again, kind of down in the weeds, but some of you may be practitioners who have cases like this and should recognize that new change. Let's flip, please. Data on commitments. Okay, this is close to home for me. I've been working with other advocates to try to require as an adjunct to DJJ realignment that we actually compile a uniform and decent statewide picture of who the kids are that are going into secure youth treatment facilities statewide. You know, DJJ had a terrific research division and kept full data on all of its kids. If you wanted to know whether they were, you know, Black, Latino, Asian, or something else, you could find out. If you wanted to know gender, you could find out. If you wanted to know how long they stayed, you could find out. None of that was translated into DJJ reform to require the same data bank to be maintained on kids in SYTFs. And our attempts to add that over the last couple of years have failed. Probation chiefs haven't liked it. The governor hasn't liked it. It's very tough to get a new data mandate, even if we're just trying to create a parallel data system to what we used to have at DJJ. So we do have those BSCC counts of how many kids are in an SYTF that you can look at, but we don't have data available on characteristics, baseline terms assigned, review hearing outcomes, and so on. I'm hoping we can do better later, but in the meantime, we did have one change under AB 102 this year. OYCR is tasked to collect time-limited data for 3 fiscal years on some of these SYTF commitment points. How many kids were committed to an SYTF, finally disaggregated by offense, age, gender, and race ethnicity. How many youth were adjudicated in a county for a 707B or former DJJ sex offense? How many kids are committed in these FY years to an LRP, and some more information on transfer hearing. So OYCR is tasked with doing that. I don't know where you guys are in that, but at least that will be a start toward hopefully getting a more ongoing uniform picture of who's in SYTFs. Let's go to the next slide. Continuing policy and program concerns around SYTFs. So it's been 2 years since we created SYTFs in 2021. Counties scrambled to open SYTFs for 707B cases that can't go to DJJ, and that should not go to adult court just because we did realignment. So it is a work in progress. Everybody knows that, and we're doing the best we can. I think it's a pretty good structure to start with, but it's not finished. Right now, 22 counties don't have an SYTF, and so they have to, if they have a case, a 707B case, that requires secure confinement, they have to cut a deal with another county. So that's one concern. Most SYTFs are sited within juvenile halls that were never built or planned to be long-term confinement facilities with suitable full programming for kids staying for periods of years. So the quality of programming, the quality of care, huge open issues. The experience in LA, I don't need to, dig into, but a lot of issues around the types of facilities and the quality and nature of programs in juvenile halls that are SYTFs. We don't have a lot of programs that are dedicated to the SYTF population for females, sex offenders, and mentally ill youth. Some, but not a lot. Net widening remains a concern. As I said, we don't have the data on how many kids are being committed, but one goal we all had in designing the system was that the new system should not be a kind of catcher's mitt for a lot of kids that would never have gone to DJJ in the first place. So we need more data to figure out where we are on the net widening front. And then in terms of oversight, there's a split of facility oversight responsibilities between BSCC and OYCR, and I've mentioned the lack of data. So these are just some of the ongoing policy concerns. Let's flip. This year, we also changed OYCR law having to do with the Ombudsperson Office and with their responsibilities for investigating complaints of kids who are in confinement conditions and so on. So the Ombuds Office was set up as part of DJJ reform, and OYCR has an ombudsperson staff that responds to complaints. We changed the law this year by expanding the ombudsperson authority to do certain things. We added in AB 505 that the staff must now conduct a site visit of every county or local juvenile facility, including contract operated facilities, at least once per year. We authorized ombudsperson staff to access and observe county facilities without prior notice. Used to be that they had to give 48 hours of notice, which raises an issue about, you know, getting ready for the inspection and so on. So this changes that. I see Catherine's note, and when I'm talking about data, okay, I'm sorry, I get it. Thank you for that. I was looking at a chat note. So the and further changes were made in the ombudsperson authority about meeting with local staff. Again, don't have to give advance notice. Current law provides that the ombudsperson can refer complaints to another body for investigation or resolve them locally. And AB 505 adds that OYCR can also recommend changes to improve local services. These changes are replicated in a budget trailer bill, very complex kind of interchange between, you know, which bill controlled it, but AB 505 is the main one. I will say this, AB 505 began as a huge reform measure that would have transferred all of BSCC's juvenile justice tasks to OYCR and set OYCR up as the central command post for juvenile facility oversight in California. So that was kind of a major policy battle, the outcome of which was that the bill was trimmed back, that BSCC retained the standards and inspections functions that it has now, but it did include these ombudsperson office changes. Let's go to the next slide. This year, we also had legislation changing the planning and development of block grants for DJJ realignment. So under realignment, the state funds counties to the tune of about $200 million a year to pay for the shifted caseload. And those funds are made available based on a plan that each county submits to the state. The requirements of those plans were changed in 2023. Kind of upgraded. It was a little bit of the old battle between probation control of the local planning committees and community-based agency and advocacy involvement. So this bill, these bills really came out in favor of changing the, hang on one second, I want to check something. I think, yeah, this is not, this slide did not correct something. It's one of the older programs that I sent to OYCR. So the only technical change here is that these changes come about through AB 505, not through AB 134 as shown on this slide. So for you techies who are wondering about bill origins, there's an error on this slide. But having said that, plan changes were made as amendments to section 1995, and you can see them here. Some of the key ones are that the plan needs to be reviewed and renewed every year now, not once every 3 years. The probation chief is no longer the mandatory chair. It can be either the chair or the co-chair. Community members must be involved in the development of the JJRBG plan. And OYCR has a little stronger role in approving the plans, not full approval, but they can kick the plan back to the county if all the required elements are not included. So those are some of the changes in the realignment block grants and their changes to section 1995 of the WIC. Let's go to the next slide. So I'm getting kind of near the end here. I'm looking at the time. I probably have about 5 or 6 more minutes. We're going to move now to changes in transfer law. And we had an important one in 2023 with Senate Bill 545. So, you saw the slide on the declining number of transfers to adult court in California, mainly propelled by Prop 57, SB 1391. But transfers have also dwindled because there are new requirements for what the court has to find in making a transfer decision in a transfer hearing. And that was changed this year again. So there are 5 major criteria the court has to consider when weighing whether to transfer a young person from juvenile to adult jurisdiction. You can see them listed here. I won't read them. 5 major criteria. And then Section 707 that has these 5 criteria also lists sub-criteria that the court may consider under current law. Under this change, the court must must give weight to any relevant factor, including all of the sub-factors listed under each of the WIC 707 major criteria. That was discretionary, but now this really forces the court to give full attention to all of the sub-factors listed under the criteria in Section 707. I put an example here. So under the degree of criminal sophistication criterion, now the court shall give weight to the statutory sub-factors that include the minor's age, maturity, intellectual capacity, and so on. So now the court, under this bill, which is now law, has to conduct a more thorough and balanced review of all those sub-factors. I'm going to skip the trafficked youth amendment because of the time. Let's go to the next slide. Another bill, AB 1643, restitution dollar amounts. So this is pretty straightforward. Current law says that if you have a restitution damage value of $1,000 or more, you become ineligible to be assigned to informal supervision under WIC 654 or 654.2. This bill raises that threshold to $5,000, so it widens the ability to get into those supervision programs. In the same way, current law requires referral of the offense to the DA for a filing decision if the restitution value exceeds $1,000. That's now up to $5,000. So that mandatory referral doesn't happen until you hit the $5,000 mark now. So that's that one. That was easy. Let's go to the next slide. So we have some other enacted bills of interest. They're not huge bills in my mind, but they're still important. SB 448, Becker amends the detention criteria in WIC 635 and 636 to say that a court's decision to detain a minor shall not be based solely on the minor's county of residence. So if you have a kid from another county, I guess keeping him locked up for a long time because he's from another county is not going to be okay on its own. Also, that the court must give equal consideration to releasing the minor on home supervision, which could include electronic monitoring regardless of the minor's county of residence. So that's the Becker bill. Mandatory drug education and treatment programs, Senate Bill 46 by Roth eliminates the requirement of current law that a minor adjudicated for drug possession must participate in a court-ordered program of drug education and treatment. That's no longer mandatory and taken out of Section Health and Safety, Section 11373, and applies to the parents as well. So relief from mandatory participation in those programs. Another bill, BSCC, AB 268, BSCC still controls the standards for juvenile facilities and inspections and juvenile grants until OYCR takes them over in 2025. That board will have 2 new members under this bill, a licensed healthcare provider and a licensed mental or behavioral healthcare provider to be appointed by the governor and confirmed by the Senate. So changes on the BSCC board. And a techie change, SB 883, the Public Safety Omnibus Bill clarifies that when electronic monitoring is ordered by the court shall review the EM order no less than once every 30 days versus every 30 days. Clarifies that it can be more frequent. as a review for kids who are on electronic monitoring. Next slide. So a quick note on a couple of notable vetoes. Two big spending bills were knocked out by the governor. One, a Jones Sawyer bill that would have tried to spend nearly $250 million on a cluster of youth programs, including a renewal of his youth reinvestment grant programs. Governor's veto said that didn't have enough money in the state budget, deficit, and so on, so couldn't afford it. Same veto message for Pacheco's AB 695 that wanted to direct state funds to the infrastructure of Los Angeles County juvenile detention facilities. Yes, they need it, but this wasn't going to be the way it happened. Governor said we don't have the money to do that. Next one, and my last slide. Pending in 2024, we have 2-year bills. This is the second year of a 2-year session. And again, I don't think any blockbuster bills sitting in the mix, although new bills could be introduced, but this one is a biggie. This one is a biggie, and it's sitting on the Senate floor ready to pop out. AB 1186 Bonta would completely revamp juvenile restitution law. That's been a kind of a thorn in our juvenile justice side for a good long time. And it would ban court-ordered monetary payments by youth or by their parents, and instead say that victim economic losses will be compensated through the Victims' Compensation Fund. The restitution orders would then be limited to non-monetary community-based restoration programs. And there are numerous other changes in restitution law. So it's gotten all the way through the process to the Senate floor, and bears watching. Next slide. That's it. I'm done. And it's a couple of minutes before 1. I went a little bit over, and if we have time for questions, fine, but I leave it up to you, Judge Lucero, and thank you.
Yeah, I think we'll go ahead and power through. I did want to acknowledge that 505 didn't give OYCR anything extra around reviewing county plans, David. We always had the ability to ask for revisions. So I just wanted to clarify that, because I know it was a very complicated situation, and just didn't want people to walk away thinking we got that power through 505, that was already part of it, part of SB 823, I should say.
Yes, the language changed a little bit, but you're right. Thank you.
Yeah. And then, and I did want to also acknowledge that any of the policy opinions that are being expressed by David, of course, are his right. But OYCR is appreciative of all the stakeholders during this realignment, including the probation chiefs, including probation facility managers, boards of supervisors, CEOs. We've had a huge undertaking. This has been a huge undertaking, and every single person has been vital to its success. And I can tell you that there is a lot of programming going on in the SYTFs, and that OYCR is doing its best to make sure and provide technical assistance around some of the more complex areas. But I just wanted to kind of put that out there to kind of a palate cleanse for the next speaker. So LaRon, go ahead.
Okay. Do you want to see, is anybody interested in asking questions, or shall we maybe wait and do questions for everything at the end, I guess, if you want to? Looks like there's something in the chat. David, it's about your PowerPoint.
Yeah, there's a question about whether or not David's PowerPoint can be sent to the participants, David, after they're corrected.
Yeah, that's fine. Let's just make sure we have the most recent one, which I'm not sure made it into the mix, because there are a couple of errors
Yes.
About which bill did what in the
yeah,
the answer is yes. We'll fix it and make it.
Okay. Thank you, David. Thank you so much. And then we have a hand by Edgar Villegas.
Hi, yes. Um, well, first of all, thank you for giving us this marvelous presentation. I really appreciate that. My question is in regards to the AB 505, when the complaints investigation and the facility site visits. If I had a youth in a facility that was post-release is now being, having issues with his probation officer or probation overall, and is trying to advocate for himself, would the AB 505 be for him? And if so, how would he be able to connect with them? Because he's been expressing complaints, and just to kind of have a better understanding of this and to, pass along the information. How you wanted to ask, how would I be able to have in contact the ombuds the what?
Ombudsperson.
The ombudsperson, yeah, the ombudsperson.
I defer to you on that, Catherine.
Yeah, thank you. We can put a link into the actual chat. If I know our lots of our staff is on. Ahmed, I think I saw Ahmed on, our deputy ombudsperson. We will get a link into the chat, Edgar. There it is.
Thank you very much.
Okay. We were also asked when this will be available. The recording will be available, and we will try to get it up by Friday onto our website. Okay, we're going to go ahead and move on to LaRon's portion, and then we'll take questions again.
Great. Okay, Austin, if you can do the PowerPoint for me, thank you. So good afternoon, I'm LaRon Dennis. I'm going to do what will not nearly be as interesting a presentation now on some of the cases that affected juvenile law in 2023, and maybe a couple are maybe late 2022. So go ahead, Austin. And you can go ahead and pass this one as well. Okay, so first I want to give a shout out to the probation folks on here. I know that the legal stuff is important for you for probation conditions, making recommendations to the court. So I'm going to assume that you all are up to speed on the language. If I say anything or use an acronym or a phrase that you're not familiar with, don't hesitate, excuse me, to drop the question in the chat. But I appreciate that you guys you're here. And I know there's a lot of probation folks. Okay, so the first case is a DEJ case, ME versus Superior Court. This is a case about a late report. It's a sex case. The offense was committed while ME was under the age of 18 and over the age of 14, or 14 and older. But prosecution didn't occur and a petition wasn't filed until he was 25 years old. So by the time the case went to court, he was 26. And the probation department and the judge found that he was eligible and suitable for DEJ. And upon appellate review, the court held that technically, because he was under 18 at the time of the offense and over 18 at the time of court, he could be eligible for DEJ. Because he was 26, as opposed to 18 or 19 or even 20, he couldn't receive DEJ because the court would have no jurisdiction over him if he would end up failing DEJ. As you're probably aware, the general jurisdiction age statute is 21, except for those real serious offenses in 707B. And so because this person was 26, the court wouldn't have any jurisdiction over them if they were to fail DEJ, so they could not be placed on DEJ to begin with. Next slide, Austin. The second case, this is a Hunter W case, is about finality of cases once appeals are over. In this particular case, the law setting the maximum time of confinement changed after Hunter's case had been made final on appeal. And he was hoping that he would be able to take advantage of the new max time reduction when the law changed. And he asked the court to change his max time from 7 years to 6 years. And the court said because his case was final, it was unable to review the dispositional order and alter his max time. There's an interesting discussion in the case about the juvenile court's jurisdiction and how it can look at cases after disposition for things, for petitions 778, 779, 779.5, which is a change of circumstance after a disposition has already been ordered. But just because the court has jurisdiction to do that, it doesn't have the ability to change the dispositional order, something like the max time. So his max time remained at 7 years. Go ahead and change the slide, Austin. Thank you. This is a probation condition case. In this particular case, Casey had committed a forcible rape and forcible sexual penetration of a child under the age of 14 and received a probation condition from the judge, basically prohibiting that he have any unconsented sexual touching of another person. And Casey challenged that probation condition as being vague, so unconstitutional on vagueness grounds. The court reviewed it and felt like the language that was used was clear enough to provide fair warning of the conduct that was going to be prohibited by the probation condition, which is the standard for vagueness. You have to be able to understand, what a reasonable person understand what the probation condition is prohibiting. And in this case, the unconsented touching of another person was something that the court felt could be understood by KC. Obviously, it's the circumstances would have to be something that was considered specifically if there was an allegation of a violation. Did he or the other person understand what his intent was when if there was touching? But the court felt like this particular condition gave fair warning to what was being prohibited. So you can go ahead. Thank you. The Jenkins case is not a juvenile case. It's actually an adult case, but there are a couple things I think that make this case interesting. For one, it talks about the responsibilities of a prosecutor and an attorney general who handles appeals generally speaking, for the district attorney's offices. And that they both have the same responsibility, even post-trial, to turn over evidence that could be beneficial to a defendant if they were to be in possession of it or should have knowledge about it. The Attorney General's office has that same burden or duty that a prosecutor has. And in this particular case, Ms. Jenkins felt that she didn't receive a fair trial because the prosecutor had been aware of a prior juvenile offense by one of the other parties in the case, one of the victims. And she felt that because that information about this victim's juvenile history didn't come to light, it might have helped her at trial. And so the prosecutor had a duty under Brady to disclose that. And this is a California Supreme Court case, and the Supreme Court held that it was a violation of Brady, and that not only the prosecutor, but now upon appeal, or it was a habeas corpus petition, but basically an appeal that she had not had a fair trial, that the Attorney General was also in possession of this information or had knowledge of it, and that they were then in turn required to disclose it, both under the Constitution for a fair trial, and they have an ethical duty under the California Code of Professional Conduct, Rule 3.8. There's some other responsibilities under habeas corpus law as well. But the other interesting thing about this was the court went into pretty great length to describe the process under which an attorney general, if this were to happen again, would have to disclose the evidence of the confidential juvenile file and let the petitioner or the petitioner's attorney be made aware that there might be information in a confidential juvenile file, tell them how to file a petition for disclosure, and then make the materials available for the court to review. So the court could make a decision about whether or not this information should be disclosed. Okay, go ahead, Austin. The FM case is a case about Welfare and Institutions Code Section 702. There have been a lot of cases over the years that talk about W&I Code 702. It's the requirement that when the court has before it an offense that could be either a felony or a misdemeanor, it has to declare whether they're sustaining the petition as a felony or as a misdemeanor. They have the discretion to do either, but it is harmful and error if they don't say specifically on the record that they knew they had the discretion and that they exercised their discretion when they set when they sustain the petition or go to disposition. It has to be done by the time they go to disposition. And I think it's interesting because a lot of times the juvenile court will say things during taking the admission or during the disposition, like, you know, FM, you should know this case, this charge could be considered a strike. This is a serious or violent felony. Anything like that. I could send you, back in the day, I could send you to DJJ, or I could send you now to an SYTF. By saying that, the court's implying that it's sustaining the offense as a felony, but the court has to state on the record that it's aware that it has the discretion to sustain it as a felony, and it is choosing to do so, and not just setting the max time at the level of a felony. That isn't sufficient. And in this particular case, there was conversation on the record, and there were even some judicial council forms and minute orders where certain boxes were checked or where they had written notes about the offense, but the court didn't acknowledge on the record that it was using its discretion to set the charge at a felony level. Okay, go ahead. This is a case about AB 12, the extended foster care provisions. We don't have a lot of those in juvenile justice. They happen a lot more in the 300 dependency court realm. But in this particular case, this young man had been released from custody and was living in a sober living environment. He was telling his probation officer that he was employed and had been following the rules. AB 12 outlines certain things that non-minor dependent children have to, or non-minor adults have to do in order to be eligible for AB 12 funds. And he said he was doing all of the things he needed to be doing, but he wasn't providing proof of that. Eventually, he left his sober living environment and couldn't show that he was living in an approved home. He said he was working, and then he said he wasn't working at all. He missed a couple of his court dates. And even though his attorney argued that because of his autism, he wasn't being purposefully uncooperative, he just couldn't manage all of the things that he needed to manage on his own, and asked the court not to dismiss his status. But the court went ahead and terminated his AB 12 services and jurisdiction. And the appellate court held that doing that was error, because when deciding whether or not to terminate AB 12 services, the court has to look at not just is the person meeting all of the requirements, but is it in their best interests? And you'll find that the provisions of best interest in Welfare and Institutions Code Section 202 and also in California Rule of Court 5.555. And because in this case, the probation officer in the probation report recommending termination didn't say that it was in the best interest to terminate, and the court didn't check the box on the judicial council form that said it was in the non-minor's best interest to terminate, the court sent the case back so that they could have an additional review and the court could reconsider whether or not it was in Jonathan's best interest to terminate his AB 12 jurisdiction. Next one. The EP case is an example of a transfer hearing case. And I think we'll probably have some more of these as Section 707 has been amended. This case was not final. It was still pending appeal when 707 was amended to change the prosecutor's burden during a transfer hearing from a preponderance of the evidence to clear and convincing. The clear and convincing standard, I think David mentioned that in the legislative update. The clear and convincing standard is a little higher bar for the prosecutor. It's not as high a bar as, say, beyond a reasonable doubt, but it's more likely than not. And it's a higher standard than the preponderance. In this case, the court specifically said that they didn't feel that because the standard was different at the time EP had his transfer hearing, that the court would likely do the same thing if they used the clear and convincing standard. So they sent it back for the court to consider that. The other thing that was talked about in this particular case was EP and his attorney failed to ask that the prosecutor put on a prima facie hearing prior to the transfer hearing. A prima facie hearing is basically an opportunity for the prosecutor to have to show a reasonable or probable cause that the minor was involved in the offense that led to the filing of the transfer motion. So a strong suspicion of guilt that the minor participated in the offense that led to the transfer motion. But in this particular case, the appellate court said that even though it was forfeited on appeal for not having raised the issue in the juvenile court, based upon the evidence that was presented, a prima facie case was made during the transfer hearing, so it was okay. Also, I think because it's always interesting for people, I think probation officers and attorneys alike are interested in when the court does an analysis in a transfer case, what are the things they consider, what kinds of factors does the court need to look at, and how does the court weigh those factors? And so this particular case gave some language around what to look for. So when the court's doing its analysis on a transfer hearing, the appellate court suggested that the court is required to consider all 5 factors together in determining whether or not the minor's amenable to rehabilitation. So like the previous version, the court could, when the standard was just a preponderance, the court still has to look at all the factors in the totality. You can say unfit or transfer on one offense, or you can say based upon 3 offenses or 5 offenses, all 5 of the factors, but there has to be a totality of the circumstance looked at. So weighing all 5 of them. And I think that's probably all I'll say about this. Go ahead, Austin. The next case is also a transfer case. Similarly, the court sent this case back so that the juvenile trial court could reconsider transfer with the new standard, the preponderance standard. And I think the court also felt here, because of the higher burden on the prosecution to prove the minor should be transferred, it might come out differently. The other thing that's interesting about this case is that there was a psychological evaluation and an expert that testified at the transfer hearing. And in her opinion, the minor had enough mental health issues that some of the behaviors that the court felt made him unamenable to juvenile rehabilitative efforts, she felt were due to his mental health. And so after opining about that, the courts, for some reason, sort of dismissed it as not being persuasive. And so this appellate case, there's quite a bit of discussion about the need in transfer hearings for there to be expert testimony, that because of the nuances of adolescent brain development and trauma and mental health, educational deficits, that it's important to have an expert that can advise the court. And it's even more important for the court to actually listen and take in the information that the expert is providing. And I think it's kind of something maybe we look to see if it happens, but in particular, this appellate opinion was written with the suggestion that going forward, instead of what used to be fitness hearings now being called transfer hearings, this court recommends that that we start calling them amenability hearings. That if the ultimate question is whether or not a minor is amenable, maybe we should call them amenability hearings instead of transfer hearings. So we'll see if that catches on. Okay, Austin, go ahead. So this case is a competency matter, Welfare and Institutions Code 709. We haven't had a lot of these lately, which is, I guess, maybe a sign that the legislation around 709 is fairly settled and we haven't had too many changes, so there haven't been a need to have many cases interpreting it. But in this particular case, this young man had been found incompetent, and unfortunately it was during COVID, and he was in custody for 15 months. Now the statute 709 establishes the maximum period for the time of remediation at 1 year. So obviously he's in custody for 15 months. That's 3 months beyond the remediation period. But the appellate court held the remediation period is 1 year, but the court has the ability to continue the jurisdiction for a reasonable period after that in order to settle the issue of competency. So the other thing that was a challenge during this COVID period was there was a dispute between the parties about whether or not the prosecutor in the case was entitled to retain their own expert and whether or not the minor had to participate in an examination by the prosecution's expert. And the appellate court held that yes, that the prosecution is entitled to retain an expert and the minor can be examined by that expert. And it went ahead and said, although it's not ideal, and certainly in some cases it might not have even been acceptable, but because of the COVID challenge and because of the delay in having a hearing to determine whether or not the prosecutor could have an expert, that going beyond that 12 months and having the minor in custody for 15 months was okay. The other thing that came up was Welfare and Institutions Code Section 709 specifically talks about a 6-month hearing that the court has to determine whether or not it looks like the minor is going to regain competence. And even though the statute doesn't specifically mention that there's a 12-year hearing, a 12-month hearing, it implied that there must be, because the competency period could go on for at least 12 months, there had to be another hearing that would come up. So even though the statute doesn't specifically say it, there is both a 6-month and a 12-month hearing that can be had. Okay, Austin, go ahead. So this is a United States Supreme Court case. And again, it doesn't necessarily apply to a juvenile justice matter, but it's related to ICWA. And because ICWA does apply in juvenile justice court, I thought it would be of interest. This case was challenged by families that were trying to adopt Native American children, and they were also joined in the case by the state of Texas. And it was a challenge to the Indian Child Welfare Act itself. And the Supreme Court ruled that Congress can regulate Indian affairs broadly, but also family law issues. And even though that's not common, that's generally left to the states. It is something that that Congress can regulate. And some of the specific challenges, one was a 10th Amendment challenge that ICWA forces state officers to engage in the enforcement of a federal law. And the Supreme Court said because there are also private placements, private adoptions, and people coming to the court to seek private intervention, in not just state action in custody issues, that ICWA wasn't co-opting state officials to enforce federal law. There's also private party actions. So the 10th Amendment wasn't violated. I think for those of us that work in a state where there are lots and lots of Native children and we have lots of ICWA application, we were kind of hoping that they would maybe go a little bit farther in talking about some of the other issues to protect ICWA, but the court decided not to deal with the issue of equal protection due to their belief that the parties lacked standing. So the families were claiming that their equal rights were violated because ICWA gives preference to Native families and tribal organization members as opposed to non-Native people when they want to adopt or become foster parents. But the Supreme Court decided that they weren't going to deal with the equal protection issue because they didn't feel that the parties before it had standing. So I'm guessing we may see something maybe in the future in that area. Go ahead, Austin. Thank you. So this is a dismissal case under 782. That law has evolved quite a bit over the last year. Actually, probably even more than that. There seems to always be something happening with 782. It basically gives the court the ability to set aside the findings and dismiss a petition if it believes that the interests of justice require that, and that the welfare of the person who's seeking the dismissal requires that. This particular case was used not in the way that we often see it. It's generally speaking, I'd say the majority of the time, that the young person and his attorney are seeking to have a 782 dismissal, maybe so they can have a record sealed if it's a 707B offense, or coming back before the court even after they become an adult to have a 782 motion to dispose of a petition. But in this particular case, the court decided to set aside a charge that was not a 707B offense, allowing a earlier in time 707B offense to be the basis of a secure youth treatment commitment. As you know, in order to commit someone to an SYTF, the offense has to be a 707B offense. And in this particular case, JP had committed a non-707B offense after the 707B offense, and they were on the same petition. And so even after sustaining the petition, the juvenile court decided to use 782 to set aside the findings and dismiss one charge on the petition, the non-707B charge, so that the court could commit this youth to the SYTF. And the appellate court said that that was okay. Go ahead, Austin. Thank you. Here is a record sealing case. As you know, 781 and 786 are the Welfare and Institutions Code provisions for record sealing. 786 is the one that we do probably far more often nowadays. It can happen at the time probation's dismissed in the court. It's, I think, sometimes referred to as automatic sealing. In this case, this person came back to court after having been off of probation and having had their record sealed. And they had discovered that there were other agencies out there who had copies of their juvenile record that had not been ordered sealed by the court previously. And I'm sure you can imagine this is probably not uncommon. We think of the police agencies and the probation department and the district attorney's office having those records, but unfortunately, those records sometimes get out to schools or other counseling programs, places where the youth may have received treatment. And so in this case, the person AB came back to court to ask the court to seal with a second petition. And the court decided that it didn't think it had the authority to go back and open a sealed record for purposes of doing another sealing petition. So the appellate court said no, to the extent that the court was going to have to access the sealed records just to rule on this second sealing petition, it had the authority to do that. And particularly because one of the reasons that the court is allowed to look and inspect sealed records is when the person who is the subject of that file asks the court to access the records. And that was the case here. AB had asked the court to go back in and do another sealing to sweep away those other records that had not previously been sealed. And the appellate court said that that was fine. Okay, Austin, go ahead. So this is the very first case that I have come across that is actually dealing with 875 and the 6-month time reduction, 6-month review provision. It's brand new. It was the opinion came out at the very end of December. And I think it's the only thing out there right now that provides guidance on some of the considerations when the court hears a 6-month review and is asked to do a 6-month time reduction. So it's an interesting case. This particular person, Tony, had done very, very well in his SYTF. He was participating in his programs. The probation officer's report for the review basically said he had done everything that was asked of him. The only thing that had happened during his 6-month commitment was there was a reference to 2 fights that had occurred, one of which Tony was the victim. But other than that, everything else he had done really, really well. And the court basically said, well, that's great, and I'm glad to see it, but 6 months is too soon for me to decide whether or not we should reduce your baseline commitment by 6 months. So the court chose not to do that. Now, there is something made in the case about the fact that the judge that was doing this review was not the same judge that had originally dispositioned Tony into the SYTF. And so there was some discussion about whether or not that was fair or prejudiced Tony, because he believed that the other judge had basically led him to believe that if he did everything he needed to do program-wise, he would get a reduction. But the court didn't make a whole lot of that, because the same information would have been presented, and every judge potentially is going to hear these reviews and come to different conclusions. But in this case, the court just said, no, I just don't think 6 months is enough to know if all of these rehabilitative programs are really going to stick. So we need more time. So the appellate court agreed and said, basically, just because he's done well, he's not entitled to a baseline reduction at the 6-month review. There are lots of other things that the court can consider. And as outlined here, as you can see, not just whether or not they were programming well, but specific progress on the individual rehabilitation plan, the treatment needs and the goals that were identified in the IRP, the length of time expected for rehabilitation. Oftentimes that's a consideration when the baseline term is set, depending upon the minor and depending upon the offense. The court can sort of look at how long do we think this person needs to be rehabilitated, and that's how they set the max time. So reducing the max time will shorten what the court is saying the length of time needs to be for rehabilitation. So whether or not the court is willing to do that shortening, they can take that into consideration before they decide to do a reduction. And also protection of the public. The court can specifically say they're not ready to reduce the baseline term because they're not sure short of that baseline term, the public would be protected if the minor were to be released. So this is the first case out there that kind of goes through all of these criteria and factors, and will provide some guidance for the probation folks here that are writing those review hearings, and for the defense and prosecution attorneys that might be listening, sort of what is it that the court can look at and what's persuasive, what the court doesn't have to consider, or what the court should consider. This is a good case for all of that. Okay, go ahead. So this it happens to be a juvenile case, but more specifically, it's a constitutional Second Amendment case. I'm not going to go into a whole lot of discussion about the United States Supreme Court ruling in New York State Rifle and Pistol Association versus Bruin, but New York had a law which is somewhat similar to California's that required an applicant for a gun license to show that they had proper cause for carrying the gun. And the Supreme Court, the United States Supreme Court, held that that was a violation of the Second Amendment. And California has a good cause provision in its licensing framework as well. And the Attorney General's office has has just agreed that that particular thing is unconstitutional. And so that phrase is no longer a consideration in the gun licensing application process. Well, DL had a petition sustained for a homicide, an assault with a firearm, and carrying a loaded firearm. And he basically challenged the gun charge based upon the US Supreme Court's ruling in Bruin about gun licensing. And he felt because that particular provision, the good cause licensing provision, was unconstitutional, it basically was unconstitutional to punish someone because they were carrying a license in public without carrying a gun in public without a license. And so the case was heard, and it wasn't about the murder or the firearm, the use of the firearm. It was strictly about his carrying of the gun. And the appellate court basically said that California's Penal Code Section 25850 doesn't violate the Second Amendment just because of the good cause requirement being disproved. It can be severed in the entire framework in California of guns being licensed, and the court could keep that separate. And that in this particular case, just because that particular provision was unconstitutional didn't mean that he couldn't be punished for carrying the loaded gun in public. So it happened to be a juvenile case, but it's more of a Second Amendment case, which would apply across the board in California. Okay, go ahead, Austin. Okay, this is another Second Amendment case, and basically the same thing happened. The court held it was fine for him to have a petition sustained for carrying a loaded firearm. But the real meat of this case was a suppression motion that the minor ran after he got contacted by the police. And when they finally caught up to him, he had a gun, and he wanted to have the search that resulted in the gun found to be unconstitutional under the Fourth Amendment, because he said the police didn't have probable cause to search him. And I think it's an interesting case because under the totality of the circumstances, and that's how these are evaluated, would a reasonable person have thought, under all of the circumstances that happened at this time of the search, would they have thought that they were free to leave while the police were talking to them? And in this case, the minor ran. And I'll quickly summarize what the circumstances were. A bunch of kids are standing around, and a couple are in a car. Police come by, and they say they smell the odor of marijuana. So they stop to talk to the kids. And they manage to get one of the kids out of the car, and they pat search him for their safety while they're talking to him, and they have him sit on the curb. And then they talk to another kid who's standing outside, standing outside the car, and they do the same thing, pat search him, have him sit on the curb. Then they turn to this minor, and the officer says, "Come over here." And the kid says, "Why?" And he says, "I just want to talk to you." And he starts to run, and they chase him and catch him. The officer pat searches him. Interestingly, he doesn't find the gun at first, but gets him back. And when he goes to put him in the police car in a little bit to actually take him and arrest him, he does a better search, and then he finds the gun. And the minor appeals, saying that he should not have been able to search him. And I personally think that this isn't really even a close question about whether or not he was free to leave. If you're sitting there and all of your friends are being searched, and you're called over because you know you're about to be searched so that they can talk to everybody, I don't think a reasonable person would assume that they were free to leave. So unfortunately for the minor, he wasn't free to leave, and the finding of the gun was a lawful search. So those are all of the cases that I have. I'm happy to answer any questions, or actually I can answer questions and we can open it up. Austin, if you want to get rid of the PowerPoint, maybe we can see everybody and see if questions of me, questions of David. No?
Yeah. Any,
I have not looked at the.
LaRon, did you want to speak about the case in 2024 or did you cover that, the 6-month review?
Yes, I did. That was the
Okay.
Tony case. Mhm.
Okay. Any other questions?
No?
Okay, I think somebody's going to post a survey. David, did you have anything else to add before I close?
No, thank you. I think that was great. LaRon, you did a great job. I just would like to make sure that the corrected PowerPoint is the one that goes out from here on. We already talked about that.
Oh, you
Yeah.
know what, David, I will quickly mention the one piece of legislation that you passed over because I know you were worried about time. And if you want to jump in, correct me, or get into greater detail, go ahead. There is a new provision in consideration of transfer if the minor is potentially the victim of human trafficking or sexual abuse. That's something that the court can hear about and would prohibit transfer if it turns out that the minor, the person that he or she harmed, is someone who sexually abused them or trafficked them. And that can also be grounds for transferring a case back to juvenile. Right. If the case has already gone to adult court and it comes out that the minor is the victim of trafficking or sexual abuse. So.
Yeah, exactly. And I did skip over it in the interest of time, and it's in SB 545.
545. Okay. I don't have anything else.
Okay. I would want to thank each of you for participating. We have posted the survey. Remind you that on February 5th, we have Clinton Lacey and LaRon talking about credible messengers. Clinton Lacey is one of the founders of Credible Messenger Movement, also called Credible Mentors. And then we have on March 4th, Lenore Anderson, who's going to be presenting on victims and the justice system, myths, facts, and new solutions to better serve them.